advocating illegal drug use, and this decision provides no support for any restriction that might be a comment on a political or social issue, including speech on the wisdom of the war on drugs or of legalizing marijuana. So that if the student speech were, if Frederick's banner had said legalize marijuana, different result. That's core political speech, advocating a change in the law, not advocating illegal drug use, advocating its legalization. And that would be core political speech, and according to Alito and Kennedy, would be protected. And it was clear from the argument in the case that one of Alito's concerns was religious speech, that students during the course of the school day might pipe up, conduct some kind of religious-based demonstration, or exercise their vocal cords to say something that was religiously provocative, and he didn't want students to be punishable for that. So he, with Kennedy, joins the Roberts outcome on the understanding that this message advocated illegal drug use and goes no further. It's an extremely narrow decision in that respect. And Justice Breyer over here waffled as usual. He decided that Deborah Morris, as the principal of the school, had an immunity from being sued because of what she did here, and Breyer declined to reach the First Amendment issue. So he didn't express any opinion on that issue. And then, of course, you've got the dissent by Stevens and Souter and Ginsburg, and it's a split decision. What is the holding of the court in Morris versus Frederick? This is one of those fairly unusual cases, not so unusual, where the court actually tells you what the holding is. In many cases, you have to read the decision, read the facts, read the court's reasoning, and then distill from that what it was that the court actually decided. What was the rule of law that emanates from the court's consideration of the facts and its application of the law? Yeah.
Holding this case, if I understand correctly, is that student speech is not protected if it is pro-illegal drug use during school hours.
Basically, that's it. Yeah, basically that's it. The court says right on the first page of the opinion, we hold, about to announce the holding of the case, we hold that schools may take steps to safeguard those entrusted to their care, a nod in Thomas's direction, from speech that can reasonably be regarded as encouraging illegal drug use. And the court restates it a few pages further on. Roberts restates it just before Thomas's concurring opinion, referring to the special characteristics of the school environment and the governmental interest in stopping student drug abuse, that those factors allow schools to restrict student expression that they reasonably regard as promoting illegal drug use. So that's the holding. That establishes the precedent for Morris versus Frederick, so that when the next student speech case comes along, the court deciding it will look to Morris versus Frederick and decide whether the holding has to be applied here. Well, if it's a sign that it can reasonably be interpreted as advocating illegal drug use, Morris versus Frederick will be applied, can't be distinguished. Say, oh no, this one's different, and will govern under the common law method the outcome of the next case. Yes. Well, the concurrences, I don't think they joined, I'm not sure of this, I don't think they joined Roberts' opinion. I think they simply concurred in the result. The result was Frederick loses, but for the reasons that we express in the concurrence, not for the reasons that Robert explained. They want to limit the holding of the case. Well, in a case where the court's not so badly splintered, it's pretty easy. When the justices have heard argument, they go back to their conference room, and Chief Justice Roberts sits at the head of the table, and the 9 justices are there. Nobody else, only the justices. They have to keep their own notes of everything. And Justice Roberts said, okay, how do we vote in Morris versus Frederick? And they go around the table, and each justice says, vote to reverse, I vote to affirm, and so on. And you count the heads. They're not explaining anything at this point, they're just voting. They count the heads, and if the Chief Justice has voted with the majority, that is at least 5 for one particular outcome, then the Chief Justice assigns the writing of the majority opinion to whoever he wants to. It can be himself or one of the other justices who voted for that outcome. And if the Chief Justice is not in the majority, then the assignment is done by the senior justice that voted with the majority. It's an important power, the ability to assign things. In this case, Roberts had the votes for the outcome. And then he circulates his opinion, and his opinion did not completely satisfy Alito, Kennedy, and Thomas. They were going to stick with their vote that Frederick loses, but for different reasons. So they wrote concurring opinions. Somebody over here. Yes, if by used as precedent, you mean it can be cited favorably in a later case. I mean, very frequently, lawyers making their case in a brief to the court will quote from somebody's concurring opinion or dissenting opinions and so on. You know, as Justice Stevens said in the Citizens United case, blah, blah, blah. It has persuasive value, but it's not binding on the next court. Only the holding of the case is binding on the next court. So what were the precedents that the Morse court had to confront in dealing with the facts of this case, of Morse versus Frederick. Yeah.
First one was Tinker versus Miller. It's got what the school did was one where our dance protest Vietnam.
Right.
And then the school said school made it will elaborate our dance and students that go forward and go forward. And the final result is that students had free speech as long as it didn't disrupt like regular school like work. It was harmless under our dance.
Students won that case. Tinker versus Des Moines. That was the first real student speech case. Was Tinker. What else? Catherine? Mm-hmm. So who won the Fraser case? Sorry? The school district won because, according to the Supreme Court, Fraser did not have a First Amendment right to make the speech that he did, and the court said that the rights of school children are not automatically coextensive with the rights of adults. You might be curious about what Fraser actually said in his speech. He got up on a table in the school lunchroom, it was a high school lunchroom, and made a political speech for a candidate for a student government office. And here was the speech. The court didn't put this in the decision. I had to ferret it out all by myself. Here's his Matthew Fraser's speech. I know a man who is firm. He's firm in his pants. He's firm in his shirt. His character is firm, but most of all, his belief in you, the students of Bethel, is firm. Jeff Kuhlman is a man who takes his point and pounds it in. If necessary, he'll take an issue and nail it to the wall. He doesn't attack things in spurts. He drives hard, pushing and pushing until finally he succeeds. Jeff is a man who will go to the very end, even the climax, for each and every one of you. So vote for Jeff for ASB Vice President. He'll never come between you and the best our high school can be. It's brilliant, right? It's brilliant. Not a dirty word in the speech. Not a vulgarity in the speech. You know?
So then how does this court have the right to say that it's indecent speech, not political speech? That's just one reading of it. They said that there were different readings for the banners, and I think they're reading
Well, it tells you something about Chief Justice Roberts. He says that while on its face it's a little cryptic, his word, the school principal immediately thought that this is a plea to use marijuana, that it promoted marijuana use, that it was either advocating marijuana use or celebrating marijuana use, and either way the school had an interest in preventing that kind of advocacy or celebration, and that it was reasonable for her to conclude that those were the proper readings of this cryptic banner. In other words, what Roberts did is defer, pay deference to the judgment of the responsible government official, which is the kiss of death in a First Amendment case, because the government will always have some interest that it advances as essential, a competing social value that the government says is at least as important, in this case more important than the free speech of school children, that needs to be served by a restriction on this kind of speech. Robert?
Interpreting it to say one thing where it could just as well, be saying something completely different. And I think that.
Well, let me deal with that. I think Chief Justice Roberts would say the opposite, that we exercise judicial restraint when we defer to the expert judgment of government officials who are responsible, rather than impose our own values. Doing that, deciding cases according to what we want as judges, is the opposite of judicial restraint. Judicial restraint is deferring to government officials, not overruling them because you think they made a lousy decision. Right, you can't be too deferential, otherwise you don't have a First Amendment, because the government is always going to have some reason that it elaborates to the court why they have to restrict this particular speech. And if you're completely deferential, that swallows the First Amendment.
Right, and even, I think the point that stands out to me the most comes from the dissent, where, they're writing that, admittedly some high school students see those who drug or don't. But most students, however, do not change their way to full case, and most students don't have when they see it. It seems like in the tradition or in the principle behind the First Amendment, that we should refer to people who have some common sense that this is just stupid, versus referring to a government official who's hurting free speech, even though it might be said to be reasonable.
Mm-hmm. There's a sort of a double dip, a double dose of deference here. They defer to the government officials' interpretation of what the banner said, and they defer to the governmental judgment that exposing school children to information advocating drug use will harm them, will result in harm. No evidence of harm caused by a silly banner like this. But the court just skips over that. No need for government to prove harm, because the government has, and I think everyone would agree with this, the government has an interest in curtailing illegal drug use. Almost everyone, yeah. Yeah, well, that brings up the third precedent that the court had to confront, which was the Kuhlmeyer case, which involved school officials censoring a school newspaper, where the court emphasized the special characteristics of the school environment as limiting the speech rights of kids in school. I don't think it's a matter of turning 18 as much as it is getting out of high school. I mean, if you're 18 and not in high school, then you've got all the rights of an adult. And if you're out of school, you have all the rights of an adult. But if you're in school, you have limited First Amendment rights. Sure. If it's a private school, would the case have gone anywhere? And what's the answer to that? Well, the answer to your own question. And now tell me why. Why? A private school is not the government.
So in this situation, if the whole, it seemed like the whole argument was you're promoting illegal drug use, and that was it seemed like the main focus. Once they, labeled it gibberish, and not even know was didn't cause harm, why was he still, why did the judges so hold it? I would think that they would reverse it once they realized that it didn't know.
Oh, well, that's a different question for private school, public school. Yeah. Yeah, well, I can only say what the court said about the gibberish. I mean, the two ways to interpret this sign as promoting or celebrating drug use. And all Frederick can say is it was gibberish. It didn't mean anything. And it was reasonable for the school officials to conclude that wasn't the proper reading of it. On the private school, public school, Stanford, for example, a private university, can have rules about student speech that Cal can, because Cal is the government, is public, is part of the government. And you're quite right that, and this is Roberts, what role did the 14th Amendment play in this case, which is the issue that you raised? And somebody want to spell that out for me? What role did the 14th Amendment play in this case? Well, it was a negative role, in that if there hadn't been the 14th Amendment, as John says, there wouldn't be any case. Frederick wouldn't have a prayer. He wouldn't have a plausible claim at all, because the First Amendment itself applies only to the federal government. Congress shall make no law. And the 14th Amendment's due process clause says no state shall deprive a person of life, liberty, or property without due process of law, and the court has interpreted that clause of the 14th Amendment to apply First Amendment rules to the states. Absent the 14th Amendment, Frederick wouldn't have had a case at all. He had to be relying, although everybody talks about it as a First Amendment case, it was really a 14th Amendment case, because it's the 14th that incorporates the First and applies it to the states. If the banner had said legalize marijuana, how would the court have decided? We've dealt with that. It's political speech, not advocacy of illegal drug use. If the banner had said Jesus loves you, how would the court have decided? I think that's protected speech too, right? Alito and Kennedy certainly would not want that kind of speech to be unprotected. If the event had occurred after school hours, how would the court have decided? After school, not during school, right? Would have been protected because the principal comes on the PA and says the Olympic Torch Parade is going to pass by school 5 minutes after the final bell, and we invite you all to come outside. We've got bleachers set up on both sides of the street so that you can observe the parade. Behave well, enjoy the parade, see you in a few minutes. But it's after school hours. It's hard to know. That's a fact whose significance is probably not determinative, yeah. Mm-hmm. Mm-hmm. What if the banner had said, Frederick comes back with a slightly different banner after the decision, and he really wants to praise Justice Stevens for his eloquent dissent in the case. So he comes out with a banner that says, "Bong hits for Stevens." Could that have been libel?
If you interpret it as saying that Stevens advocates illegal drug use, and you know that that's false.
Yeah, well, we'll put that on hold about libel for a couple of weeks. What's in?
I was in that because the claim is the banner saying Jesus advocates for Bong hits, you can take that law for Jesus.
That would be a tough case too. Then I don't think we know. I mean, if the school principal says, "Oh, that advocates illegal drug use," you're at it again, Joe. You're out of here for